Hey, thanks for joining us for another episode of Estate Planning Nightmares and How to Avoid Them. This is a show which highlights the importance of estate planning and why everyone needs to do it. And of course, the unfortunate consequences of what happens far too often if people have not planned or at least planned properly. I'm your host, John Braddock, the author of Click Here When I Die and the founder of My Life and Wishes, The Legacy Vault, an online planning and document storage solution created to make things easier for those you love. Today, I'm joined by Suzanne Feinberg, and this episode is going to be a little bit different and I think extremely educational. In most of our shows, we talk about and focus on not planning and the nightmares that it creates, right? So today we're going to discuss something a little bit different, and that's making sure that all your documents are correctly executed to make sure that they work the way they're intended. And before we jump in, I want to tell you a little bit about Suzanne. She co-founded AZ Roving Notary. Sidebar, the AZ stands for Arizona. So she founded AZ Roving Notary in 2019 after a 15-year career teaching professional photographers how to create and market digital products, photo tours, and workshops using internet marketing. And as an early adopter and pioneer of remote online notarization, Suzanne was in the first 100 notaries in April of 2022 to be commissioned, or 2020, you're right. I'm getting ahead of myself. It's during COVID.
Yeah.
Commissioned as both a remote online notary and electronic notary when then our governor of Arizona, Doug Ducey, put an executive order in place for emergency online notary services. Over the last 4 years, Suzanne has established working relationships with online platform vendors such as Secured Signings, Pactima, and Signix. Further, she has helped those online providers develop improvements in functionality and their overall user experience. Her relationship and status with these vendors have led to platform training and consulting for many of their clients, including law firm staff, as well as independent notaries. AZ Roving Notary specializes in the execution of estate planning documents, both as traditional notaries as well as remote online notarization. Suzanne has taken the necessary steps according to the laws and regulations of the state of Arizona to become a qualified custodian for Arizona electronic wills, which brings up some questions in my mind that I'll be asking her in just a few moments. Arizona Roving Notary, or AZ Roving Notary, has set up an independent custodial accounting system that meets all the state requirements for storing of electronic wills. The one thing that clients notice most about Suzanne is her dedication to creating a successful online signing session, regardless of the signer's technical abilities. Because she has discovered the secret to successful signing sessions, she has also created an online course for notaries at an affordable price so that other notaries could run successful online sessions as well. Her strong commitment to her professional and personal communities. She's a national speaker, and her most recent engagement was leading a workshop at the National Notary Association 2023 conference. Outside of participating in speaking, podcasts, and guest blogs, she served on the board of the Arizona chapter of the American Society of Media Photographers for several terms. And as a professional photographer, Suzanne volunteered with Flashes of Hope, a nonprofit group that takes portraits of families with children in their final stages of cancer. Additionally, she served 2 terms as an appointed commissioner by the city of Scottsdale on the library board. She is a graduate of Scottsdale Leadership and participates regularly with alumni activities. And Suzanne, interestingly enough, has also successfully completed Scottsdale's Citizen Police Academy. And in her homeowners association, she served on the board of directors in various committees, helping her community to improve their financial and environmental strengths. On the personal side, Suzanne loves to photograph at all the national parks, as well as train her Bernedoodle Maggie with the necessary skills to be a service dog. Welcome, Suzanne.
Hi, John. Thank you so much for having me on your podcast. And just a little aside, last night I went to a Scottsdale leadership alumni meeting, and Waymo was the speaker on technology. And it was so exciting to see the technology and to find out how those self-driving cars actually worked. It was a lot of fun.
It's amazing. And for a lot of our listeners that may not be in the Arizona area, and I don't know how things spread out. We all know of Uber starting out with the self-driving cars, right? Well, down here, Waymo is like way bigger than Uber is in developing that tech. And it's really strange when you're driving along next to a car with people in the back seat and nobody in the front seat.
So today I'm here to discuss a real nightmare, and I know your podcast is about the nightmares of estate planning, but this nightmare could happen to anyone who wants to execute their will electronically. And I'm finding that as I talk to my contacts, they really don't understand the consequences of creating an electronic will and testament without having a custodial account and qualified custodian. In fact, most of my contacts, most of the lawyers out there, most of the people doing electronic wills fall into one of two categories. The first group is not aware of the laws involved. And since they execute so many of their documents online, such as the power of attorney or beneficiary deeds, they just assume that the will can be executed online as well. The second group knows the law, but they're scared to implement the will online. They fear the security of the online process, and they fear the consequences of not being able to provide a qualified custodian or a custodial account. But I'm here to clear up the main questions involved with the production and storage of electronic wills and to turn that nightmare into a sweet dream. But first, I have a very important disclosure, John, and I'm sure you know what's coming next. I'm not an attorney or anyone who can practice law, so the information I'm going to be giving your listeners is distilled from my online searches, classes I've taken, experience out in the field to become more proficient in offering these services to my clients and talking about them to people who want to know more about them. So I advise your listeners to specifically look at the laws themselves and to contact their legal advisors for further clarification. And just as a little aside note, the laws on electronic wills are really easy to understand for a layman. It's just there's a lot of them, and they're written very tiny when you do the printout. So, but they're really not that hard to understand and to be successful at it.
Oh, absolutely. I imagine. And always a good point. If I have a lot of attorneys on, if they're an attorney, great. If you're not an attorney, the advice you're given is not legal advice. It's based in your universe and what you do. And I'm really excited to talk about this today because I really want to start with what is an electronic will? Because I don't clearly have a grasp of that. If someone said to me, what's an electronic will? I would say, oh, that's probably something that I just do through LegalZoom or Rocket Lawyer or something online. Is
Right.
that what it is? But how much more is there to that?
Right. So it could be that because a lot of your listeners are not necessarily lawyers, but could be people who download electronic wills from LegalZoom or Trust and Will or even the Attorney General's office. So every state has an office that puts out these senior packages that have the living documents, not usually a will that you have to go to a specific company for. But let's build it from the start with some laws and some definitions. So I spoke with the chief counsel, Benjamin Orzecki of the uniformslaw.org, and he defines it as the Uniform Electronics Transaction Act, or UETA, and the federal e-sign law provide that a transaction is not invalid solely because the document is in electronic format. However, the laws specifically exclude electronic wills. Okay, so now we can sign electronically, but we can't do our wills. So a new act was enacted, the Uniform Electronics Will Act, which allows for the electronic signature on an electronic will. Now, this is a federal law, and it's meant really as guidelines for the states. It's not really a law that says you have to do it. It states, though, that the testator, that's the person who's creating the will, their signature must be witnessed and or notarized at the same time or contemporaneously, so that everybody is there in one session and they're signing it with the witnesses there and the notaries there. And it further states that the states have the option of including language that allows for remote witnessing. So some states have language that say witnesses have to be in the same room. Some states say witnesses can be on a Zoom call like this, where everybody is together. And it allows for the language that addresses the recognition of electronic wills under the laws of another state. So what does that really mean? It means if you're in Kentucky and you write a will, and then you move to retire to Arizona, is your will going to be accepted in Arizona? So just to give you an example, when I moved from California to here, we redid all of our documents to be Arizona documents. But sometimes people don't do that because they're very complex and they just don't want to go through the process again and the thoughts that have to go into this whole estate planning issue. So what happens is a lot of times, if the will is written in a way that meets the probate laws of the state that you live in at the time you die, they will accept the will that was made in another state. And that's true for the electronic wills as well. It's sort of like that cross-state type of interstate commerce. It's compatible to something like that. So what
Yeah.
is an oh,
Yeah. So what is it? And then I want to find out because we talk about these various states. So that'll lead to my next question. So exactly what is that electronic will?
okay. So we're going to look at this from the viewpoint of Arizona's House Bill 2197, Title 14, that was revised on April 11th of 2023 and put into effect on July 1st, 2023. So we'll start with the term electronic. Electronic means having electrical, digital, magnetic, optical, electromagnetic, or other similar capabilities. Okay, next step. What is an electronic record? An electronic record means a record that is created, generated, sent, communicated, received, or stored by electronic means. Okay, so now we know what electronic is and what an electronic record is, but what is an electronic signature? So sometimes you think of it as a digital signature. This particular podcast, we're not going to go into the details of the difference. Just know that a digital signature is more secure than an electronic signature, and Arizona interchanges the terms without thinking about it because they define what goes into an electronic signature. So it's attached to or logically associated with an electronic record that is executed or adopted by a person with the intent to sign the electronic record. And it uses a security procedure that allows the determination that the signature was all of the following. It was unique to the person, meaning it's unique to you, John. It's capable of verification. I can pass it through, let's say, Adobe Acrobat Pro, and it'll tell me the signature is valid. It's under the sole control of the person making the electronic signature, meaning I, as the notary, can't sign your document. You, as the signer, have to sign it. Okay. And if there's a signer and two witnesses and the lawyer's in there and the notary's in there, the only person that has control over that signature on that will is you. Okay. And then it's linked to the electronic record to which the electronic signature relates in a manner so that if the electronic record is changed, the electronic signature is invalidated. So it means if you have the PDF of the will and it's signed and somebody comes in and takes out page 2 and substitutes a new page 2, the verification process knows that the document's been tampered with and invalidates the signature.
Wow.
Okay, that's the whole thing about remote online notarization that we're not going to go into, but just keep in mind that those are the things, those are 2 of the 3. The third thing for an electronic signature is that you're electronically present, meaning 2 or more individuals in a different physical location, like you are at your office and I'm in my office, and who are communicating by means of a technology that enables all of us, you and me, to see and hear each other in real time, just like Zoom, to the same extent as if the individuals were physically present in the same location. Meaning, you and I could be sitting across from each other at your desk doing this podcast, or you and I could be here in different locations. But that is electronically present. It's as if we were together. Okay, so there's all these strict rules, regulations, laws, and they're all enforced by the Arizona Secretary of State, and believe it or not, by the Secretaries of States of every other state. So now let's define what an electronic will is. This is a testamentary instrument that's executed and maintained on an electronic medium, and that's in compliance with Arizona Section 14-218. Okay, people can look that up. I'm not going to keep reading laws to people. But that's what an electronic will is. Somebody has signed it electronically and it's stored electronically.
Okay.
Okay.
So that's Arizona. And, all states differ to some degrees in what they allow. So what states allow, or if it's a shorter list, what states don't allow an electronic will?
Right. So the shorter list is which states allow. And I could only find data as of the beginning of 2023. So if anything happened in the middle of 2023 or in 2024 to add states, I'm sorry, it's not included in this. But if you're from a state that I don't list, please check it yourself to see if you can do an electronic will. So Arizona and Florida are the leaders in the security of electronic wills and have the best rules and regulations for the security and for the comfort level of the lawyers and of the people making the wills. Nevada has also been around a long time doing electronic wills. And then we have Idaho, Illinois, Indiana, Maryland, Minnesota. Somehow or other, Colorado has sneaked in not in the alphabetical order, but North Dakota, Utah, Washington, and then you have the District of Columbia, Washington, D.C., and the Virgin Islands, which I couldn't find a definition for which Virgin Island it was, but it's one of the U.S. Virgin Islands. The balance of the states and territories, it's very unclear whether or not they allow electronic wills, and it really goes by the state's definition of the term writing. So is writing handwriting? Is it typing? Is it dictating? Is it visual? What is the definition? And every state defines writing in their rules about wills.
Yeah,
so one of the interesting things is that some of the states I name are stricter than other states. When I say stricter, I mean they have to have things like a qualified custodian, and they have to have custodial accounts, and there are laws about what specifically has to be done within these and how to become one are very specific.
Okay, so if you're in one of the states that allow, good for you, and you can look into the steps and you get these things done. If you're not in one of the states Suzanne listed, and you think you actually have an electronic will that you have done, incumbent upon you to check, do some research in your state, find out what's required. Hopefully everything is great. You might want to perhaps contact an attorney or someone else to find out whether or not it in fact would be valid.
Here is another point about it, and that is electronic wills can be done with remote online notarization, or they can use what's called in-person electronic notarization, where I come to you, your will is on my tablet, you sign on my tablet, I stamp and seal it on my tablet, and then the PDF then goes to you, to your lawyer, to the custodial account, depending on what your state laws are. But there's two ways to do an electronic will.
Okay, good point. So I heard you mention custodial accounts a couple of times. So can you explain, in layman's terms, what is a custodial account? Why does it need to be included for the electronic will? And how does that work together?
All good questions and points. So I'm going to start by saying Arizona, Florida, Indiana, and Nevada all require a custodial account. Okay. And according to a law firm I do business with in Tucson, even if your state doesn't require a qualified custodian or a qualified custodial account, you'll want your will to be easily admitted to probate. So you probably should have a qualified custodian and use a qualified custodial account. So what exactly is this custodial account? Each state defines it differently, but basically it's a method of storing the last will and testament, which I will interchange with the word will, as well as any statutory requirements to add to the account. The storage account has to be in the control of a qualified custodian, and the only person allowed access to this account is the qualified custodian, and if there's a backup qualified custodian assigned to the account. The testator is never allowed access to the account. It can be a cloud account or a detachable hard disk to your computer. It can reside with your lawyer. It could be with your financial planner. It could be something that a notary firm has, like we have. But in any case, you need to have a backup arrangement. So you can't just do a sync account or a Dropbox. You want to have a backup just in case they're hacked or just in case they go down or whatever, and you need access to that information. We use Sync for our custodial accounts. We love the encryption, the automatic backup, the password protection with two-factor authentication, the audit trails on who's entering the account and when, and all the other security features that that platform offers. And a lot of the things I just mentioned are mentioned in the laws. So the Sync account really meets those qualifications for being a custodial account. And even though we have the Sync, we have a backup feature, which is that our remote notary platforms all have storage capability. And the only one who can access that storage is the notary in this case being the qualified custodian. But let's say they wanted somebody else to be the qualified custodian and they had their own custodial account, then that person would have to have a backup system because the notary can't back it up for themselves. Because here in Arizona, we can't store documents unless it's the custodial account. And then if your state doesn't require a custodial account, I can think of 3 reasons why you should. And so I used ChatGPT. And I'm telling you this because people who use artificial intelligence to create things should let people know that they came up with the ideas and ChatGPT just massaged them into a better format. So we're being transparent here. So the first reason I came up with was custodial accounts provide a secure way to store your will. They're typically held by trusted financial institutions, legal entities, or independent qualified custodians such as AZ Roving Notary here in Arizona, or John Bain of Florida Document Specialists in Florida, because Florida has the strictest rules of anybody. And custodial accounts offer protection against loss, damage, or unauthorized access. A second reason to have a custodial account would be legal compliance. By storing your will in a custodial account, you can ensure that it meets all legal requirements and it's properly executed. This reduces the risk of challenges to your will's validity if it goes through probate and helps ensure that your final wishes are legally binding. And finally, there's the aspect of confidentiality. Custodial accounts offer a level of confidentiality, ensuring your will remains private until the time of your passing. And this can be important for maintaining privacy regarding your estate and beneficiaries. I mean, think about it. You have 2 sons, they're in business with you, and one son does better than the other, and you really don't want either of them to know that you're going to give everything 50-50, because that would destroy the son that did more and make the son that didn't do as much happy, or vice versa. So you can sort of understand that confidentiality issue.
Yeah. It's interesting. Talk about that. And I think about like the first will I ever had when a long time ago when I was in my 20s. And I had it done by an attorney, and it was there, and it was in my desk drawer. That's where the the signed original of it. It was in a desk drawer. And I think about that today. And you talk about people being able to see it before you want them to see it, or things like that. It seems like this is a much better process to have this thing locked down in a vault somewhere where only the custodian can access it.
Right. So what's that expression? Do as I say, not as I do. I won't even tell you what my bills are, where my important documents are and everything. We're now starting to learn about where to keep your documents and how to store them online and things. That's something that we personally, my husband and I are looking into at this particular point for myself and for my clients.
Well, it's interesting because, do as I say, not as I do. I was speaking with someone earlier this week, and they were telling me about an estate planning attorney of 15, 20 years who recently passed, who did not have an estate plan.
There you go.
Wow. Right.
There you go.
Too busy helping everyone else to then turn around and get their own done.
Yeah. By the way,
so, yeah.
you had Marjorie Desmond on your podcast a few weeks ago, and that's how I came across your name. And I just have to say, she's one of the best estate attorneys that we've worked with, and just give her a little shout out there.
Oh, that's terrific! Shout out to Marjorie. Yes, I've known Marjorie for several years. She's absolutely wonderful. And in addition to having her on this show, I had her on another show that I hosted with another gentleman about a year, 2 years ago, called Legacy and Libations.
Oh, there you go.
The show where we talk about life, death, and the beverages that get us through.
Exactly.
And she was on that, and yeah, she's just very engaging and charismatic. So wonderful person. So, all right. So we know what electronic will is. We know what states allow it. Obviously, the ones that we didn't list don't allow it. We know which ones are the toughest, and then we know that 4 out of the 12, 15 that allow it require the custodial accounts.
Correct. But you need somebody to take care of it.
Right. Yeah, exactly. And especially because people don't talk about this stuff, right? It's like, I got a will, I got it jammed in a drawer or a estate plan, and I've got an executor or trustee listed on there, and they have no idea that that is their responsibility when I don't wake up some morning, right?
Right.
So I think it's a great idea, and I like the whole custodial aspect, even if you are not in a state that requires it. Who can be a qualified custodian? I mean, you mentioned now your firm you've gone through the steps in the process, but who can be a qualified custodian? What goes into that?
Okay, so if your state requires a custodial account, or you decide you want to do it on your own, you want to have a custodial account, then you're going to need that qualified custodian to monitor and maintain the account. And each state defines it differently, but basically, and I've distilled all the laws down to this. A qualified custodian is an independent person who ensures that the electronic last will and testament remains untouched, unchanged, and in their custody until required by probate, or until the person takes it away from you, because you can transfer. 2 agreements are signed and stored in the custodial account. An agreement that the testator says they agree to use that qualified custodian, and then an agreement by the designated qualified custodian that she or he will perform, or they will perform, the required duties as outlined by the law. So an example of state differences is that Florida requires the qualified custodian to have a specific amount of insurance, and that the qualified custodian reside in their business resides in the state of Florida. Arizona doesn't have any insurance or residency requirements. So that's a difference, and that's why you have to look at the state laws to determine, can you be or who should be a qualified custodian in the states that specifically state that you need one. And since most states specifically outline the requirements for the transfer of guardians is accomplished to the law, here what we do is we have a backup qualified custodian. So let's say here at AZ Roving Notary, I decide I want to retire in 5 years. But you're 35, you just signed a will, you may not need it for a very long time after those 5 years. We have a younger backup qualified custodian that's going to take over the account. So that agreement will be signed with both of our names. And it creates a very smooth transition to the backup guardian without a lot of paperwork being generated, meaning that there are a lot of laws about transferring the account. So rather than having someone go through all that paperwork that's required, we just get a backup custodian to manage the account should we decide to close business or not be a qualified custodian anymore. So they'll take over for us.
That makes sense. Another question that comes to mind, because you mentioned, you've got your kids in the business with you, and you're going to split things 50-50, but one of them is not going to be very happy, right? Because he did all the work, and whatever the situation is. So let's say, I've got electronic will. It's in, custodial account. Obviously, I can't get my hands on it. But now I think, you know what? That one son I need to just cut out of my will. I need to update the will. How does that process work? I mean, is it just an addendum to the will that then comes in, or does the whole will come out and is it redone and then put back into the custodial account?
So there are several ways to change a will, and I'm not an estate lawyer, so I can't really tell you what those ways are. But one of the ways is a codicil. And if you do a codicil, it follows the same laws as the will itself. In terms of electronic wills, it would have to be done electronically. It couldn't be manual and kept in a drawer. It would have to be stored with the will itself. Or if they decided to rewrite the will completely, then basically what they do is they close the account. They say, okay, we don't need it anymore. Then as a qualified custodian, we save the account for X number of statutory years, depending on what state you're in. And we set up a whole new account for your new will. Because remember, unlike my life and
wishes.
My life and wishes. Unlike that, you don't have access. You have access to all the documentation, but in the electronic world, you don't have access to the account. So now you're going to ask me a very interesting question, and that is, what if I want a copy of my will just to look at all the time, or to send to my lawyer, and it's in my life and wishes or some other platform that's similar to your platform? What do I do? So what I do as a qualified custodian and as a notary, when I'm sealing all the documents, I make a copy of the will, a PDF copy of the will, and on it I have a watermark that says copy, not for actual use, or whatever the watermark says. I don't have that in front of me right now, but I make a copy of it, and then they come to you and they've got their healthcare power of attorney, and they've got their trust, and they've got this and that, but they also have a copy of their electronic will to look at. And that way is it the circle of what do you call the people that are like able to do things with you?
Authorized user, but I like the circle of trust.
Yeah, the circle of trust. I think actually I got that from a different company, but yeah, there's a circle of trust, or people that you've allowed to get into the account to look at things in case something happens. Then then they would have this copy, and along with the copy, it would give instructions about what to do in case of death, to get the actual copy of the will. And so we're getting
like saying that I have a custodial account, and here's who the custodian is, and this is who you need to call.
Right, exactly. And then just to stay on that same topic, which really wasn't part of this, but the when somebody dies and the will goes to probate, or if they're transferring the account or closing the account, the person actually gets a certified paper copy of the last will and testament. So who certifies it? What is that? Well, it's just a paper that has the signature of the custodial qualified custodian, and I've created a little seal that I put on it that says certified by qualified custodian. And then I'm signing the document, and I actually get the document notarized so that, my document, my certification is notarized, and then the actual paper copy that is valid is attached to it. It's no longer an electronic will, it's a paper will. However, you make any changes to it, it won't be valid. You can't make changes to an electronic will.
Right. Gotcha.
Okay.
Well, that
Okay.
makes sense. Here's another last question, because we're winding down on our time. But before we wrap up, I really have two questions. One, so we know, your online notarization, you create the custodial account, so you can be a custodian. And so I think that's highly important, and people, especially here in Arizona, should pay attention to that. What other services does AZ Roving Notary provide?
So we have sort of two parts to our company. The first part and the most important part is we do remote online notarization. That is the mainstay of our business. And we concentrate on estate plans, but we also do a lot of corporate legal department work. So anytime we have major corporations that will call us up, and their president is overseas, overseeing their factory in France or Ireland, and they need to get a lease signed and notarized and apostilled. So we will go ahead and we can notarize documents from wherever you are in the world, in the universe. You might be on the International Space Station and your wife sold your house and you need to have a document notarized with your signature. We can do it if NASA will give us access to the space station. So, it's primarily remote online notarization. And then if it needs to be apostilled, which is the process of authenticating who verified the signature and the person signing, so it would be the notary. Or it would be, if it's a certified copy of a recorded document, it would be like the Department of Motor Vehicles, it would be the birth certificate or whatever. It goes through a process with the Secretary of State, and we go down there for you, and they do this apostille, they put a certificate on it, and then we mail it back to you, and it can be used in a foreign country. So we do a lot of expats in Portugal who want permanent residency, and they need to get a Portuguese driver's license. So we do 5-year motor records. We do FBI background checks, a whole lot of things. We don't actually do the background checks or get the documents, although we can. We do charge a hefty fee on that because that's not our main business, and we have to go through third parties to help us with that. The other thing I do is I teach notaries. And I teach notaries how to run a successful notary business and how to run a successful online notary session. And I teach notaries how to do internet marketing and things like that, internet marketing and how to use social media properly. Right now, I'm working on how to write the right prompts for ChatGPT to get the right information out of ChatGPT, because people like to write their posts using that. I do LinkedIn training on how to have the proper type of LinkedIn personal account and business page. We do budgets for notaries that have no budget, and we list out what's the most important thing and the order to do them in. So we do a lot of consulting to notaries on that. And we work with law firms. We love working with law firms. We treat their clients with white glove. It's concierge service. We want to make sure that client doesn't go back and say, I don't want to use that law firm because the notary was terrible. So, it's important to us to, have that relationship. And I like law firms because they give you repeat business but I take business from people who find our website, which is AZ Roving Notary. It's spelt right on the backdrop.com. And you can see our pricing. We're very transparent with pricing. You can see all the services we offer. You can reach us by typing in my name, Suzanne, Suzanne, at azrovingnotary.com. And I respond really well to emails as opposed to phone calls, because that way I can put it aside, find the answer, and I don't have to put people on hold to find answers or figure out what their problem is, because everything is a unique problem in this business. It's not something that's systemizable with the answers to questions.
Absolutely. Absolutely. And folks, feel free to reach out to Suzanne if you have any questions. I'm going to make it really easy for you. I've included all of her contact information in the show notes. So whether you're watching this on YouTube, listening on Apple Podcasts or Spotify, you're going to find it all right there. Suzanne, this has been really very enlightening for me. I thank you so much for joining me and sharing with our audience a bit about you, your firm, and of course, the importance of ensuring that things are done correctly.
Thank you so much. I really enjoyed this. And again, if anybody has any questions on this, either you can contact me, or if I can't answer the question, I will put you in touch with somebody who has the answer. I have a lot of contacts that have answers to these questions.
Fantastic. And a big thanks to all of you, our audience, for joining us. And remember, friends, your life is your legacy. So plan ahead and make it a great day.